All right, so any of you that missed any part of Chapter 3, Section 2, here are the notes. I'm going to walk through them with you. If you have any further questions, just feel free to email me or ask me in class, or both of the above will be fine. First thing we're going to talk about is the legislative branch, and we've talked about the three branches of government and their main responsibilities, but now we're going to get a little more specific into the Constitution itself and the powers that are given to each branch according to it. First and foremost, the founders believed the legislative branch to be the most important branch, but they also believed it to be the most dangerous. The reason they believed it to be the most important was because they made the laws and the regulations that would be followed in the United States. And the reason they believed it to be the most dangerous is because they had seen an elected body of representatives abuse their power before, causing what eventually would become the American Revolution, not unlike British Parliament. So they were very leery to give this new legislative branch the type of power that British Parliament had. So since they knew that it was the most important but also the most dangerous, the powers that the legislative branch was given were called express powers. And these are powers that are directly stated in the Constitution. And what that means is you can literally open a copy of the Constitution and read the express powers, and they will be very specific on the things they can do. And we're going to go to a list of what we call enumerated powers in just a second. And enumerated powers are a set of expressed powers, and they can be found in Article 1, Section 8. And the reason they're called enumerated powers is because this is a set of expressed powers that are numbered 1 through 18. 5 of these enumerated powers deal with economics, things like coining money and borrowing money, the worth of that money, levying taxes, anything and everything essentially that deals with economics on a federal level is to be handled by the legislative branch. 7 of these enumerated powers deal with defense. These are things like declaring war, which is Congress's responsibility. Common myth that the president declares war, it's actually Congress. They support and regulate armies, and they do pretty much anything logistically, with the military. But the power to actually use military force and to carry out acts of military action lies solely with the president. There are other enumerated powers is what we call them, and there are 6 of those in total. 5 of them kind of deal with very specific things: establishing post offices and post routes, and establishing courts, establishing a government for Washington, D.C., laying out how to file for patents and copyrights and things like that. But the very last one, number 18, is something called the Elastic Clause. And this Elastic Clause was designed very specifically for Congress. And the reason it was put in there was to allow Congress to have the authority to make all laws necessary and proper to carry out the other powers it is given in Article 1. So this doesn't actually give Congress one more power specifically. This was designed to allow Congress to make laws that they thought they absolutely had to have in order to carry out the other expressed and enumerated powers found in the Constitution. The problem with this is, what does necessary and proper mean? Now, obviously, that's open to personal interpretation, but what I believe the founders meant by this is that Congress had the ability to make any law that absolutely, positively needed to be made within reason, meaning that that law that absolutely positively had to be made needs to be proper or cannot infringe upon the rights of the people or take away any rights of the people. So what I believe the founders meant by necessary and proper is that absolutely had to happen, and it was happening for the right reasons. Now, this elastic clause was sort of given a broad interpretation when it was ruled upon by the Supreme Court in McCulloch versus Maryland. And essentially what happened here is the Supreme Court said, yes, the legislative branch has the power to make any law necessary and proper. And they didn't really reiterate that or delve further into their explanation, and they left it sort of a broad, vague interpretation, and that's how it has remained today. The next slide I want to go to, these are the 18 enumerated powers: lay and collect taxes, borrow money, regulate national and international trade, establish rules for naturalization and bankruptcy laws, coin money, set the standard for weights and measures, punish counterfeiters, establish post offices and post roads, grant patents to inventors and copyrights to authors, set up federal courts, punish piracy and crimes committed at sea, declare war, raise and support armies, provide and maintain a navy, make rules for the government of the land and sea forces, call on the militia or the National Guard to put down rebellion and invasion and to enforce the laws, help organize, arm, and discipline the militia, exercise control over the District of Columbia, that's Washington, D.C., and over the federal property, and make all laws necessary for carrying out its other congressional powers. So if you need to go back to and take a look at this screen, you feel free to pause it at any time and write these down, although it's not necessarily essential that you know which enumerated power corresponds with which number for the test. Really what I want you to be able to know is that they deal with economics, they deal with the military, there are some others, post offices, things like that, and the elastic clause. That's all I have for the legislative branch, so let's move right along to the executive branch. Now here it looks like I made a little bit of a typo, but the president is the one that actually leads the executive branch and is responsible to see that laws made by Congress are carried out. The difference between the power in the executive branch and the power in the legislative branch is that the powers that are vested within our executive branch and in the president are generally vague, meaning they are not directly stated in the Constitution, a lot like the express powers are for the legislative branch. And examples of this would be the president taking action to save the nation. That's something that is very open to interpretation, and it can be anything and everything that the leader of the executive branch determines in action to save the nation. Another one of these is fire officials in the executive branch. This statement doesn't actually exist in the Constitution, but it is an insinuated power. Since the president is in charge of the executive branch, he or she would have the power to fire those officials in the executive branch, people like the Secretary of State and the Secretary of Defense and so on and so forth, all the way through our cabinet. Now that doesn't mean that the executive branch doesn't have some specific powers, and it actually has 10 that we're going to talk about here. The first is Commander-in-Chief, and that means that the president is in charge of all military operations. Deliver State of the Union. This is basically a speech that the president delivers in Congress that lets the United States and lets Congress know what is happening in the United States and how we're doing. Executive branch, specifically the president, is in charge of making treaties with foreign nations. He or she is also in charge of meeting with other heads of states. This has happened a few times, and most recently with Vladimir Putin of Russia. The president is also responsible for appointing ambassadors, and these are people that are sort of go-betweens. They are individuals that represent the United States in foreign countries. The president may also pardon people convicted of federal crimes. So if a person is, for whatever reason, convicted of committing a crime that violates federal law, the president can pardon them or say, it's okay, we forgive you. The president is also responsible for ensuring ensuring that laws that are made are faithfully executed or carried out as they were designed or written. Commissions military officers, and this means that the president basically gives members of the military the ability to lead other members of the military into battle. He also has the power to call Congress into special session if the need arises to get something done or in an emergency situation. And the president is also in charge of appointing heads of executive departments, again, people like Secretary of State, Secretary of Defense, Secretary of Agriculture and Education, and all the way down the board. So moving right along, let's talk about the, the judicial branch. There are two separate systems of courts that exist within the judicial branch and that are outlined in the Constitution. State courts, whose power comes from state constitutions and state law, and federal courts, whose power comes from the federal Constitution and federal law. And the jurisdiction of both of those levels only goes as far as, for example, in state courts, they are only allowed to rule on the interpretation of the state constitution and state law, and the same goes for federal courts. They are only allowed to interpret the federal constitution and federal law. However, if you remember back to Section 1, we talked about Article 6 of the Constitution, which is the Supremacy Clause. So if there is a federal court ruling that does not correspond with a state law, then the ruling of the federal court would supersede that law in that state. How is jurisdiction determined? How do we decide which court is responsible for which violation of law? Jurisdiction is usually determined by two things: persons involved, so who's involved in the case, and the subject matter of that case. Examples here, these would be things that would fall under the federal court's jurisdiction, so federal laws, interpretations of the United States Constitution, treaties with foreign nations and whether those treaties violate the Constitution in any way, and maritime law, which are actions at sea that are, of course, United States property. And that's all I have for the three branches. This last part here, we should be able to roll through this pretty quick. The executive branch provides plans for much of the legislation that appears in front of Congress. And this is also a power that is shared by the legislative branch. They both may present legislation in front of Congress. The president can also propose legislation in front of Congress, just as senators have the power to propose legislation in Congress. And those are really the main shared powers that you would need to worry about for this specific class. The next thing I want to talk about are conflicts. And there have been various conflicts throughout the years between the president and Congress. And the biggest conflict is one that is essentially a continually ongoing conflict. Of course, what I'm talking about here is the idea that when a president is in power, whatever political party they are affiliated with is typically the party that loses power in Congress the next election cycle. And this results in the political party of the president not matching the majority political party in Congress. And this results in almost nothing being accomplished. Now, you can look at this in one of two ways. Either this forces the president and Congress and the political party system as a whole to kind of work together and make sure that only laws that are presented and that only bills that are passed would be something that is a positive thing for both political parties. And this would ensure that the laws being passed are in fact something that both political parties support. Now, in theory that sounds great, but that's not actually what happens. Normally what happens is that the majority political party will present a bill to the president that basically follows what that specific political party would like to happen. The president, being of the opposite political party, will veto that bill. It will go back to Congress, and inside of Congress, normally what happens is the political party in power does not have enough support to get a 2/3 majority to override that veto, or in some very rare cases, they could receive that 2/3 majority, although it hasn't happened very much. There are multiple times the president and Congress have accused each other of overreaching their powers, and most famous is Andrew Johnson, who was impeached because Congress thought he was overstepping his power. Of course, he was not removed from office. Another example is the National Recovery Administration, a 1935 law that was struck down by the Supreme Court for giving the president too much power. And the Supreme Court basically said, hey, this National Recovery Administration is allowing the president to take some powers that are guaranteed to the legislative branch under the Constitution. So they struck down this law. Other conflicts would include Congress and the courts. Now, in 1964, the Supreme Court ruled that both houses of a state legislature need to be reapportioned by size. And basically what was happening here is a federal court is telling a state court, or excuse me, a state legislative branch how their representation in their given houses needs to be determined. And the United States House of Representatives was very upset about this. They said the federal Supreme Court cannot tell a state legislative branch how to determine their population. So they passed a bill to strip all federal courts of jurisdiction over state legislative redistricting. And this is a power given to United States Congress because they are responsible for regulating federal courts. However, when the bill reached the Senate, it died, and the Senate killed it and said, no, we're not going to do this. This is not what's going to happen. This is a slippery slope. We really just need to get past this and move on. Most states, however, do have their state legislatures apportioned by size. And the last set of conflicts we want to talk about here is the Supreme Court versus the President. In the 1830s, Georgia had laws in place that basically discriminated against members of the Cherokee Native American tribe. And, you know, various things like you can't live here, or if you do live here, you have to live in this specific area, and various other civil rights issues. And the Supreme Court said, hey, you, meaning the people of the Cherokee, have the rights to live wherever you want. And they said, hey, state of Georgia, you're violating the federal Constitution by having these laws in place. But Andrew Jackson, who was president at the time, refused to provide the military force to carry out the decision. So the laws that were in place continued to be informally put into place, despite the fact of the Supreme Court striking those laws down. Franklin Delano Roosevelt, or FDR, also threatened to disobey the Supreme Court on 2 separate occasions if the decision they made did not match his will and what he wanted to happen. Fortunately for FDR, on both occasions, the Supreme Court did rule the same way as FDR wished they had. So that's it. That's all I have for you for this section. Thanks for paying attention. I really appreciate it. If you have any questions, feel free to contact me through email or during class or during your intervention period. Thank you very much.